Dad has 4 other children from previous relationships. We don't know if mom's working. We know she lost her job recently with Target. There are concerns that she is dating a felon. Mom was concerned with the term joint legal custody.
You're muted.
No, I'm not. You look good today.
I am not keeping my daughter from going to her mother's. My daughter has on her own decided that she wants to be with me full time and visit mom on weekends.
When you file a petition, all there are is allegations. That's not evidence. It's just allegations.
He called me a clown due to the fact that he thought that the PPOs have gotten dropped from the last court date.
She's currently ordered to pay $364 per month in child support, and that's based on an imputation of this court at $15 an hour for 40 hours a week, which simply isn't accurate at this time since she no longer has a part-time job.
Keeler hasn't completed any of the obligations that CPS required.
And the defendant was required to pay the plaintiff $2,350 per month in spousal support. Since the entry of judgment and uniform spousal support order, it is believed that plaintiff has remarried. Defendant is also paying child support to plaintiff in the amount of $984 per month.
Angel Bond versus Mark Bond.
Both parties are appearing improper in this matter. The plaintiff has filed a motion to show cause, claiming denial of parenting time in this matter. The court does note I've reviewed the judgment of divorce. It provides that the defendant will have the first 3 weekends in the month. That's your understanding, Ms. Bond?
Yeah, the way that we have it set up is that we have parenting time as agreed, and if we don't agree, then dad will have parenting time 3 weekends a month. Yes.
Okay. Well, the problem is that the judgment doesn't identify those 3 weekends, so I can't hold anyone in contempt when the order isn't clear and there is obviously open to confusion. So what the court's going to do is the court's going to clarify that judgment of divorce and provide that the defendant's parenting time will occur on the first weekend of the month in which all of the days fall within the particular month. So in June, the first weekend would be starting June 7th, 2024, and then for the next 2 weekends, and then the other weekends of the month would go to the plaintiff in this matter. You understand that, Ms. Bond?
Yeah, the problem that we have right now is Mark has decided that Abigail is going to have full-time parenting time with him.
Okay, well, if he's going to do that, he's got to file a motion. Sir, you can't have that. You got to follow the judgment, and unless the judgment's changed, so you're going to have to file a motion.
Okay, may I speak?
Yep, go ahead.
Okay, I am not keeping my daughter from going to her mother's. My daughter is 16 years old. My daughter has on her own decided that she wants to be with me full time and visit mom on weekends because of the problems that the 2 of them have.
Okay.
So my daughter has chosen, other than me physically picking her up and putting her in the car and making her go, my daughter is choosing this on her own at 16 years old.
Okay, well, as a parent, you have to show guidance, and you have to basically show her that she's going to have to go with mom. And
Your Honor, this has been ongoing for 2 years. First of all, for almost 2 years, we haven't been doing the weekend thing. We've been doing week with me, week with her for almost 2 years. So what's in the court papers hasn't even been in effect with us for almost 2 years.
That may be, sir, but the only thing that, sir, stop. The only thing the court can do is enforce the order, and the judgment provides for the 3 weekends. That's all I can do. I can't enforce something that the 2 of you have come up with and that you're doing or not doing. I can only enforce the written orders. So that's all that I can do at this particular time, unless you file. If you file a motion to change the orders, then we can address that. but that's not before the court today. And so at this point, I'm not finding you in contempt, sir, because the judgment wasn't that clear as to the parenting time. I'm attempting to clarify that, saying that the plaintiff's parenting time will be those 3 weekends, the first 3 weekends of the month, starting with the first weekend in which all of the days fall within that particular month. So that's what I can do today. If in fact there's not compliance with that, then we can look at, again, show causing once the order is clear. And sir, I will just caution you that obviously if you're not assisting in the parenting time occurring, you could be held in contempt and you could go to jail. Then the child would have to go with mom because you wouldn't be there to have custody.
All right. And
Okay?
so, I mean, and that's all well and good. What's the paper you said I have to file? Because this has been going on for 2 years. This is my daughter has been talking to me and has talked to her mother on a couple different occasions.
What you're gonna
about
have to
wanting-
do, you're gonna have to file a motion to modify custody. And effectively, what you're seeking to do is, file a motion to modify parenting time in this matter.
Okay.
So,
All
and
right.
it'd probably be a good idea for both of you. I don't know if you want to look at that now. If there is a problem between the plaintiff and the child, maybe you should seek some sort of counseling. Have you thought about that?
Yeah, that is something that I've actually, since this started in April, is something that I've wanted to do, but I've not had her with me to be able to do counseling with her.
Okay, well, the court can order that the defendant would take the child to counseling, and we could set it up with the counselor, and what would be called as reunification counseling. Sir, do you have any opposition or objection to the counseling?
Well, I would probably recommend that we allow the family court judge to discuss some of this with my daughter,
Okay,
so that she has a voice in this at 16 years old.
I'll tell you, sir, unless she testifies, that can't happen. The court cannot
And
have
she's
communication. The only time
She's willing-
a court can talk to a child is when there's a custody dispute and the court is attempting to discern the preference of the child. I can't talk to the child about disputed matters because it's not appropriate and I'm not permitted to do that.
Well, and I understand that, and I will have that motion filed today for custody modification.
Well, parenting time too.
Yeah, that's
You can file that and we can, at that point, if you want to put in that there would be, I guess I'll ask, sir, are you agreeable to counseling so that maybe we could get the counseling started?
I would have liked this 2 years ago when my daughter first started talking to her mother about this.
Well, I'm asking you now.
Because she's blaming me for not allowing her to go, and that's not the case. I'm just strictly not picking my daughter up.
I understand.
In my
Okay,
car,
we're past that.
making her go at 16
We're
years
past
old. It's
that
not
now,
going to happen.
sir. We're past that. I'm looking. Are you agreeable that the child can participate in counseling, reunification counseling with the plaintiff?
If my daughter is willing to do so, yes, I am.
Okay, well, let's do that.
Because
Ms.
at
Bond,
16,
the court will order that there be reunification counseling. And I'll leave that up to you, Ms. Bond, because you're the one initiating. You can get the name of the counselor that you're going to be doing. Provide the defendant with that. You can do an order for counseling. And then what will happen, the court would order that both parties would pay 1/2 the cost of the counseling not covered by insurance. And
Your Honor, I'm on disability and I cannot afford that.
well, then you have to, there might be somebody, like if you go through like Summit Point or someplace like that, they would have some sort of means tested and they would it would be based upon your incomes, et cetera. So you
Yeah,
can do
'cause
that.
I can't afford it. Can't even afford an attorney for this, so.
Well, do that, Ms. Bond, you can get the order. And again, try get it through a place like that, like Summit Point, that wouldn't have basically charge based upon the incomes of the parties. And you know, some case when a person can't afford it, they don't charge anything. So that might be that what happens in this case. So do that and we can get the counseling started right away. Mr. Bond's gonna file his motion. I will tell you, Mr. Bond, that when you file the motion, file it, set it, but obviously with the order for parenting time, counseling, if you would, or reunification counseling, the court's probably not going to do anything on that motion until we've had some sufficient time for a counselor to meet with all the parties. And I will tell you, Mr. Bond, it's to your benefit to have the child go to counseling, because if she tells the counselor she doesn't want to go, the court will take that into consideration.
Oh, and I understand that, and I've, you know, strictly have just followed my daughter's lead on this. You know, this is
Okay, well,
the last
I will
thing
tell you, you're the parent, you're the one to lead, not let a 16-year-old lead, because we don't know what that'll lead us to. Okay?
my
So,
daughter's
Ms.
happiness
Bond,
is
you
number
can
one.
prepare that order, submit it for the counseling, and then he'll submit his motion, and then we'll go from there.
Okay.
Okay? Thank you both. You're free to go.
Sounds
Have a good day.
April Keeler versus Daniel Miller.
Court will note the appearance of Ms. Mcneff on behalf of plaintiff. This matter is before the court on the plaintiff's motion to modify temporary custody, parenting time, and support. Ms. Mcneff.
Your Honor, I would start by saying that the last time these parties were before the court with regard to child support was about a year ago. Since then, Ms. Keeler no longer has a part-time job. Her sole income is Social Security disability, and she receives $816 per month. The disability income for the child goes directly to Mr. Miller. She's currently ordered to pay $364 per month in child support, and that's based on an imputation of this court at $15 an hour for 40 hours a week, which simply isn't accurate at this time, since she no longer has a part-time job. Her part-time job was of the nature that she could still maintain her Social Security income plus that part-time job, but now she's down to the $816 a month. So that is a material change of circumstances, and child support should certainly be revisited in order to straighten that out. That's a significant portion of her income that she is required to pay in child support. Mr. Miller has argued that Ms. Keeler still has an alcohol problem, still has anger management issues, and shouldn't be permitted to see the party's minor child without supervision. However, the court can certainly prohibit Ms. Keeler from consuming alcohol prior to or during any visits. The court could also require that Ms. Keeler have visitation with the minor child in public places or with other appropriate adults. I don't know that we need a foster care worker in order to supervise those visits. Again, a year has passed. There have been changes that should permit Ms. Keeler to have parenting time with the minor child, and the court has the ability to put some guardrails around those visits so that the visitation could be appropriate and the child could be protected. So we would ask that the court restore some unsupervised parenting time to Ms. Keeler with the restrictions on alcohol. We believe that standard parenting time is appropriate, but perhaps there could be a graduated schedule so that she could prove herself to Mr. Miller and to the child that she is able to maintain her temper and maintain sobriety. So we would ask for a standard parenting time schedule that could be a graduated process.
Okay. Mr. Miller, what's your response?
Morning, sir.
Morning.
We're not opposed to the review for child support. I think that needs to be filed with the Office of Child Support for a review. But in regards to the parenting time, Ms. Keeler hasn't completed any of the obligations that CPS required. And my fear is not only for, the child's safety and what she might do in no one else's presence, but that CPS will reopen this case once they find out he is in her care for any amount of time. They made it clear that the only reason case was closed was because she had lost custody and no longer had parenting time. So we wouldn't be opposed to that unless it was supervised. And the person that I was asking to supervise in my response, Helen Miller, is a licensed foster care worker, true, but she is also Keon's grandmother.
What are your thoughts on that, Ms. Mcneff, is to have the grandmother supervise?
Ms. Keeler is not in favor of having the grandmother supervisors. There's not a good relationship with the grandmother, and she would prefer that some more neutral person. If the court is going to order supervised parenting time, that it be somebody who's more neutral.
Your Honor, if I may.
Yeah, go ahead.
I've been working with April's parents, Ray and Bonnie Keeler. I do trust them. I believe they would also be suitable.
Well, Ms. McNiff, how about the maternal grandparents? Would that work?
That sounds reasonable to me, Your Honor.
Well, as Mr. Miller said, he does not oppose a child support review, so the court will send the matter to the referee for a child support review. As it relates to parenting time, the court likewise has no problem with, again, a standard parenting time schedule. Again, basically on alternating weekends and a midweek. I'm not going to do it for the any weeks period in the summer, because court is going to order that it be supervised by the maternal grandparents in this matter. And obviously that would just be asking too much if we're going to have to make it a week long or for extended parenting time. So we'll do it gradually. We'll do the standard alternating weekends and the midweek and alternating holidays, but I'm not going to do any extended at this point. Ms. McNiff, you can prepare that order and submit it under 7 day.
Thank you, Your Honor.
Okay, thank you both. You're free to go. Have a good day.
Johnson Jr. versus Katie Brandy.
Court will note the appearance of Ms. Reiser on behalf of the plaintiff. This matter is before the court on the plaintiff's motion for a parenting time arrangement. Ms. Reiser.
As you said, this is plaintiff's verified motion for a temporary parenting time arrangement. The parties have never been married. They have one child. He is approximately 1 year old. Dad's on the birth certificate. He signed an acknowledgement of paternity. Dad has 4 other children from previous relationships that travel freely between households. The parties separated, and I believe it was March of 2023. And they have just kind of been exercising parenting time as agreed. But a few months ago, mom stopped letting dad see the child consistently. So there's a need for at least a temporary parenting time arrangement until we can get something permanent in place. I would like to assume that you've read the motion, but I'll hit a few highlights of the best interest factors.
I have read the motions. I have read the motion. You don't have to be redundant.
Okay, thank you, Your Honor.
Yeah. So
Dad is asking for week on, week off parenting time. He has a work schedule that allows it. As I said, he has 3 other children. His biggest concern is that mom leaves the child at her dad's house for like a week at a time. And he feels as though the child should be left with him rather than maternal grandfather. Dad's able to accommodate the child's needs. His work schedule is a lot. He can care for the child. And yeah, he's looking for week on, week off parenting time, holidays pursuant to the Calhoun County guidelines. We get child support could be referred to the friend of the court. We don't know if mom's working. We know she lost her job recently with Target. There are concerns that she is dating a felon. And so he's concerned with who the child is around. He has stable housing. Both parties actually have stable housing. So we're asking for a temporary parenting time arrangement of week on, week off. I thought we had this resolved. I actually prepared a consent order that said week on, week off. Mom was concerned with the term joint legal custody. I tried to explain that that is not an unusual, that's pretty common, and that it just has to do with major decisions, medicine, education, religion. But also, I don't want to overstep my bounds since I'm not her attorney, so.
Okay. Ms. Brandeis, as stated by Ms. Reiser, again, a joint legal is pretty standard provision, means that the parties have to discuss and communicate concerning important decisions concerning the child. They don't always have to agree to those. If you can't agree, then you bring the matter before the court, but you are required to discuss and communicate important decisions. So what's your position, Ms. Brandeis?
I just think that he should get every other weekend. We've done fine with doing that recently. I don't see why it can't stay the same. I don't think he's fit enough to keep Maverick week on, week off. He doesn't keep his other kids that long, ever.
Okay. Is the child going with the maternal grandfather on alternating weeks?
He was here, so I worked 4 days on and then had 3 days off. He was here 4 days out of the night when I was working second shift. Yes, my babysitter is 50 minutes away. I wasn't driving here at 2 o'clock in the morning to get him.
Well, at this point, what the court will put in is just a temporary parenting time. And the court does note that the parties were separated back in March of 2023, that they've been doing all sorts of different things. So what the court will do is the court will grant to the plaintiff at this point the standard parenting time, which is alternating weekends, midweek, etc. This Reiser, you can put that in that the midweek would commence this Wednesday at on June 12th, and that the weekend would commence on June 14th. And then we do alternating holidays. We can do again, the court would order. I don't see any reason that he couldn't have his alternating weeks in the summer. As Brandeis, typically we do grant alternating weeks in the summer. What are your do you have any position on that?
I mean, I wouldn't disagree on that until school starts.
Okay. Well, there's no disagreement. The court will order that. We can attempt to, maybe we can get back in and review this prior to the time, be at the end of the summer at that point. Court will order that the parties would exchange income information within 7 days of today's date. And then as a result, Ms. Reiser, you can calculate the child support.
And just to clarify, so I believe summer break has started most places. So we can start week on, week off.
Why don't we start that on the would have been his weekend on the 14th.
Perfect. All right. Thank you, Your Honor.
You have
I'll
any
submit an
questions, Ms.
order.
Brandeis?
So are we starting week on, week off now or every other weekend?
No, we're starting alternate. We're in spring, we're in summer break. So we'll start the week, alternating weeks this Friday, the 14th. And then we have the midweeks on this Wednesday.
Okay.
So what'll happen is, again, you'll get a midweek on the weeks he has the child. He'll get a midweek when you have the child.
Okay.
Okay. And you need to provide Ms. Reiser with your income information within 7 days of today's date so she can calculate child support.
Okay.
Ms. Reiser, then you can submit the order under 7-day notice of entry once you have that.
Thank you, Your Honor.
Thank you. You're free to go. Have a good day.
I don't have either of your parties, Crystal or Kurt, but I'll call the case anyway. This is 2024 5/8 DM, Crystal Bauman versus Kurt Bauman, Attorney Todd for the plaintiff and Podolsky for the defendant.
Okay, I see I have notes that you did settle the matter with Mr. Brundage, and you wanted to preserve proofs, but you don't have a client, Mr. Todd.
Yeah, I literally spoke to her today at 10:30 and we went over it. And then over lunch, I got an email that she wanted to pause the process. So I called her back and I left a voicemail saying, please call me and please attend. And I I guess I'm not sure, maybe if we could adjourn this out for 30 days.
Well, you better sweet talk Miss Podolsky, because she might just say, no way, I'm not gonna pause.
Well, Wes told me as soon as the email came in because he was confused. So we called our client. Our client did not seem surprised by this and said he'll do whatever she wants to do, whether that's put this on pause, reconcile, get divorced.
Okay.
But Wes, I mean, the
Right.
judgment's done. I mean, we agree with all the terms in the judgment and the child support order. This came as a surprise to both of us today.
So Ms. Podolsky, you're the one that has the accommodating party, huh?
I do, yes.
Yes. Well, why don't we do this? Why don't I reset it for about 10 days, 30 days. And we'll have you back and be able, at that point, it is 154 days. So be ready to tell us what you're going to do at that time, or we're going to set it for a trial.
Okay.
Sounds
Thank
good.
Well,
Thank you.
other than you've settled everything, so.
It's a recorded mediation. We have it settled. It's
Okay.
recorded. It's just, we don't know what they're doing.
Okay. Well, talk to each other before the next hearing and let's see what happens. And
Sounds good.
Yeah.
Ms.
Thank you.
Podolsky, did you do a counter complaint?
No, and I mean, he's fine dismissing this too. I mean, he's good however she wants to handle this.
Okay, well,
So he's not
30
pushing
days, let us
towards
know
it.
if you're gonna go ahead or dismiss it, and then we'll get it done.
Sounds good. Thank you.
Okay, thank you.
Okay.
Have a good
Bye.
day.
You're muted.
No, I'm not.
Okay.
You look good today.
Are we in the waiting room, Mom?
The 37th Circuit Court is now in session with the Honorable Brian Kirkham presiding. Dana Allen versus Michael Noble.
Court will note the appearance of Mr. Magnuson on behalf of the front of the court. This matter is before the court on the plaintiff's motion for entry of order determining child born out of wedlock. Ms. Allen, in this case, before we can do that, we're going to need an evidentiary hearing, and I do note that we do have in the file an order for genetic testing. I assume, Ms. Allen, that hasn't been done yet?
No, it hasn't been done. But the father, the biological father, has moved to Georgia. But he also has two child support cases out of Kalamazoo County. And I am acquaintances with one of the other mothers, and she did say if worse comes to worse and it's an option for me, that she would consent to like a sibling DNA test if that's even possible. But he is out of state in Dalton, Georgia now.
And what's the name of that individual, Ms. Allen?
The father,
Yes.
Dakota Torres.
Well, the court will order the genetic testing of, again, Miss Allen, you, the child, and Mr. Noble. We can at least, if he's to be excluded, we can exclude him. And then you'll have to follow up with Mr. Magnuson on Mr. Torres.
Okay.
So, Magnuson, I think you put in an order for genetic testing, or was that you, Miss Allen?
I put the order in.
Okay. Okay.
That's correct. That's correct, Your Honor.
Okay. Miss Allen, why don't you do that? You can call Mr. Magnuson at front of the court's office after this hearing and coordinate when you can get in to do the genetic testing, and then let Mr. Noble know as well, and then he can get in and do the sample, and we can at least get that part resolved.
Okay. That will be fine. I can honestly, is it appropriate for the testing if Michael was incarcerated and I can prove that? Or do you still want it done anyway?
Oh, so, well, Mr. Magnuson, I guess it would depend on the time of conception based upon the age of the child. If, let's say, for instance, he was incarcerated until, 2 months before the child was born, obviously he couldn't be, the biological. So we wouldn't need to do the testing if in fact the facts would bear that out. I just, based on what's been filed, I don't know what those facts are yet. So
I guess I filed it wrong. I was gonna ask for the genetic testing to be in order for Dakota and not Michael, because Michael was incarcerated March 22nd of 22. I got pregnant in June of 22, and my daughter's 1 year old, and Michael just got released from prison in April of this year.
Okay, well, Mr. Magnuson, do you acknowledge that there's probably no need to have Mr. Noble attested?
It sounds like it, Your Honor, based on what is being represented.
Okay,
I'm just kind of looking forward. If those are the proofs that come out at the hearing, I'm guessing that
okay,
clear and convincing evidence standard would be met.
yeah. What we'll do, Miss Allen, I'll have you after court, you can call my office and we'll set you up. We do those hearings on Wednesday afternoon at 1:30, and we're gonna need more time when we can take some testimony because I have a number of hearings today and I can't take testimony today.
Okay.
So, if you call and and then if you can relate that to Mr. Noble, we'll have him come in and he can testify as well to those facts. And then we wouldn't need to have testing of him done, but I'm sure Mr. Magnuson will require that there be some testing of Mr. Torres.
Yeah.
And, as you proceed.
Absolutely.
Okay, but Mr. Torres at this point is not added to this case, so you'll have to file a separate action against Mr. Torres.
Okay. Yep. No problem. The prosecutor's office should be able to help me with that. Honestly, I tried to do a separate case the same day I filed this ROPA, and they told me that I didn't need to do that because I was on assistance and that the FOC and prosecutor would work with me to open a new one for him. So.
Well,
that's correct.
Okay. Awesome. Thank you so much for your help.
Thank you. You're free to go.
Yeah.
Have a good day.
You too. Thank you.
Thank you, Your Honor.
We're not really fighting about anything, no.
Is there a way I can go about seeing my kid? Because right now I currently do not.
This is the time and place set for the settlement conference in this matter, scheduling conference, whereby the court puts in place various dates as well as processes so the case will proceed in an orderly fashion. I'll first ask Ms. Sago. Ms. Sago, okay, sorry, that was the last case. I'm still on that paperwork. Ms. Tidwell, are you in this matter? You can let me know. Is there a dispute in this particular case? Are you fighting about something?
We're not really fighting about anything, no. It's more of when it comes to our child, I have always done it alone. Even after the split between me and John, I've still done it alone. I was never asked for help with our child.
Okay. Well, aside from that, I don't need the particular details. I just know, is there in fact a custody support or parenting time dispute then?
No.
Okay, and Mr. Nichols is shaking his head yes. So, Mr. Nichols, is that correct? You're disputing custody?
Yes, Your Honor. I've got record. I've tried to reach out multiple times to see him.
I don't need to know all that. I just need to know if in fact there is a dispute. So
yes.
The court will put down that there is a dispute, because if there's a dispute, then it sends it into a different track. Have any of you attempted, or are you looking at potentially, do you need any discovery? Discovery is the process whereby you acquire information from the other side. It could be on a myriad of things. I have no idea in your case what you might be seeking discovery of, but if you have desire any discovery, then you have a right to, again, have that in this particular case. What the court will do is I will put a July 1 discovery date. What means is if you need any information from the other side, you have to do that prior to July 1, okay?
Okay.
And you can do that through interrogatories, which are questions that need to be signed under oath. You can do it through request for production of documents. You can do it through depositions or any other myriad of things that are entailed in discovery, but you have to do it before that date. The court will set the matter for mediation during the month of July. I'll ask Ms. Sago, I'm sorry, I keep going back to that other case for some reason. Ms. Tidwell, are you, have anybody you'd recommend as the mediator? That would be an attorney mediator that would sit down with the two of you and attempt to resolve the case.
No, I do not.
Okay. Mr. Nichols, do you have anyone?
Nope.
Okay. The court will leave that blank, and then the mediation clerk will assign a mediator from the mediation list. You'll be contacted probably within about a week or so from the mediator, trying to set that up and telling you what the mediator does. There is a charge for mediation, as the person obviously has to be paid for their time. Court will set August 5th, 2024 at 1:30 p.m. as the settlement conference date, which would be the final hearing if we're not able to get resolution of the case. I guess I'll ask you, Ms. Tidwell, is there anything else that you have in this matter, or have any questions at this point?
So I have a folder full of like proof of like messages and like proof of like why I personally believe John Nichols should not have full custody at all towards our child. When exactly is a good time for me to bring that into the courthouse?
Well, what happens is under the case scheduling order, there's a paragraph in there that talks about disclosure of exhibits and disclosure of witnesses. And so you have deadlines, and it talks about within so many days after the first mediation date that those have to be done. You can do them before at any time. So I would recommend, if you have documents, that you would in fact prepare those and submit those as soon as possible so you don't miss a deadline.
Okay.
If you miss a deadline, you won't be able to bring them in. Okay.
Okay.
So do them anytime. You have to identify what they are. Hey, by, if you have, let's say, for instance, you had a tax return, you would basically disclose that as, let's say, 2023 tax return, consisting of 32 pages, and you're going to have to submit those in paper form. Okay, so you'd have to have your, I guess you'd say you have to have your identification of those items as to what they are. You have to provide those to the other side, so you have to provide those to defendant as well as to the court in paper form. So
Okay.
You can't just identify them. It's the 2023 tax return. You have to attach them to the document, have them attached. Let's say it was, by that time, that was your proposed exhibit 10. You'd have them marked as proposed exhibit 10 or whatever it might be. So, but make sure you pay attention to all of the dates under the case scheduling order so that you don't miss any of those. Anything
Okay.
else, Ms. Tidwell?
No.
Okay, Mr. Nichols, anything you have?
Is there a way I can, until the settlement, is there a way I can go about seeing my kid? Because right now I currently do not.
You're gonna have to file a motion, okay? The
Okay.
motion is a request of the court. You can schedule that on any Monday with at least 9 days' notice, and you can schedule that for 10:30 a.m.
Okay.
Any Monday when you give at least 9 days' notice.
Okay.
And having said that, I'll have to correct that, because the next Monday that you would do it, you wouldn't be able to, because in fact, it's the 27th is Memorial Day, and we're not here on Memorial Day. The courts are closed, but we're scheduling those on the Tuesday, then the 28th. So you could set them on the 28th or any Monday in June if you wanted.
Okay.
Okay? Anything else?
Nope.
Okay, thank you both. We'll send this out. You should get it yet this week, and comply with that, and then pay attention when the mediator contacts you and set up that mediation. Then you can go and see if you can't get resolution. Okay? Okay, you're free to go. Have a good day. This matter is before the court on the defendant's amended motion regarding custody. In this case, court will note that the plaintiff did file a complaint for custody, parenting time, and support. Defendant has filed an answer to that. Mr. Nichols, it sounds, custody will be addressed in the course of that case as we proceed. It sounds like, based on reading of your motion, that you're asking for parenting time at this time. Is that accurate?
Yeah, that's correct.
Okay. Ms. Tidwell, what's your response to the request for parenting time?
I'm willing to agree with parenting time.
Okay. How old is the child?
He just turned 1 April 18th.
Well, typically, Ms. Tidwell, just so you know, that the typical standard parenting time is alternating weekends from Friday at 6 to Sunday at 6, then a midweek from 4 to 8. Usually, if the parties can't agree as to the day, it would be a Wednesday. You can agree upon another day if you can, but if you can't, it'll be Wednesday. And then typically, too, is standard for children other than small children is alternating weeks in the summer. What you said you're agreeable to parenting time. What parenting time are you agreeable to?
About every other week.
Alternating weeks?
Yes.
Okay. Okay. Mr. Nichols, I assume that would be agreeable to you.
Absolutely.
Okay. Why don't we do that? And Mr. Nichols, you'll have to do an order for parenting time and put that again, that you would have alternating week parenting time, and that will commence this Friday, June 14th at 6:00 p.m. through the following Friday at 6:00 p.m. and then we alternate each week thereafter.
So I have a question for you.
Yep.
So I would get him this Friday?
Yes.
Okay. Awesome.
You get him this Friday, and what we'll do is, we don't need to do that this time. There's a midweek, so each party, so Mr. Nichols, when you have the child, she would be entitled to a Wednesday midweek from 4 to 8:00 p.m.
Okay.
And then on her weeks, you would be entitled to a midweek. And then you would also be entitled to alternating holidays. And there's standard alternating holidays through the front of the court, and you can look online and get that information. But because you're representing yourself, you'll have to do the order for parenting time, and then you'll have to submit that within 7 days, and then you don't need to have an additional hearing. If you don't get it submitted within 7 days, then you'll have to motion the matter up for entry, and it'll require another hearing. So I don't know if you're using like Michigan Legal Help or something of that nature, but you can go to michiganlegalhelp.org, and they have all those orders and forms and stuff online, and you should be able to just prepare one with alternating weeks, midweek, and alternating holidays.
How about
What? Yeah. And you can put in this matter, you can do a calculation of child support as well, based upon the alternating weeks. I don't know if the child is receiving any public assistance, or if mom.
Yes, he is.
What?
Yes, he is.
Okay, then what's gonna happen is we can't deviate from the standard calculation. So Mr. Nichols, you'll have to do a calculation of support based upon what each of your respective incomes are. Court will order that each of you would disclose the income no later than this Friday, the 14th. That way, Mr. Nichols, you can do a calculation, and you can get it in the order so you can get it submitted before Monday. Okay, so you don't have to renotice it up. And you can do that through Michigan Legal Help as well, do the calculation. So Ms. Tidwell, you'll have to get him your income information. He'll provide you with his income information, most current, up-to-date, year-to-date income, and then he can calculate the support and submit an order for the parenting time and an order for child support as well.
Okay.
Okay? Thank you both. You're free to go. Have a good day.
Thank you, you too.
Layla Akudo versus Norman Akudo?
Court will note the appearance of Ms. Smith on behalf of the plaintiff. The defendant is not present. Defendant, we believe, had attempted to connect a few times, and we were not able to get a connection with the defendant. What I'm going to do, because I obviously, if he is not able to connect, I'm not going to, again, prejudice him as a result of that. The matter is before the court on the plaintiff's motion for temporary spousal support. I do note under paragraph 7 of the petition, Ms. Smith, that you do list 5 different factors that the court should consider, but all I do is draw your attention to Sparks v. Sparks and the Louts case. Sparks has 12 factors the court has to consider. Louts adds 2 additional to make that 14 factors. And the biggest factor that's missing is the needs of the parties, and you didn't include any budget or anything so that I can tell what Ms. Smith's or Ms. Okudo's needs are in this particular matter. So what I'll do is allow you to amend your complaint, renotice it, and that way then we can maybe get Mr. Okudo to join at that time as well.
Okay, thank you, Your Honor.
Okay, thank you. Have a good day. Court will note the appearance of Mr. Vanderhorst on behalf of defendant. This matter is before the court on the defendant's motion to terminate spousal support. Mr. Vanderhorst, you can proceed.
A judgment of divorce was entered with this court on May 23rd, 2016. Defendant was defaulted on January 26th, 2016. The parties were married for 13 years, and the defendant was required to pay the plaintiff $2,350 per month in spousal support. Defendant is requesting that his spousal support obligation to plaintiff be terminated. Spousal support is modifiable, and the defendant has paid the plaintiff approximately 8 years of spousal support for a 13-year marriage. The Uniform Spousal Support Order did not provide a termination date or any specific language of when spousal support would end. In the Uniform Spousal Support calculations, it's believed plaintiff was imputed 0 income. Since the entry of judgment and Uniform Spousal Support Order, it is believed that plaintiff has remarried and is employed, and her current income is unknown. Defendant is also paying child support to plaintiff in the amount of $984 per month. Due to the fact that plaintiff is employed, remarried, and that the defendant has paid years of spousal support, defendant is requesting that his spousal support obligation to plaintiff be terminated and any arrears forgiven. Thank you, Your Honor.
Well, in this matter, the plaintiff has not appeared. It is now 9:42 a.m. The matter was set for 9:30 a.m. Court will note that spousal support is modifiable pursuant to MCL 552.28 and pursuant to the case of Tomlinson versus Tomlinson at 183 Mishap 589, 1990 case. And the burden is on the defendant to establish change of circumstances. Court will set the matter for an evidentiary hearing, so we can take all of the evidence that's necessary to make a determination in this matter. Court will note, based upon the pleadings in this case, that the defendant does have sufficient income to pay for the interpreter. So the court will order that the defendant do so. The interpreter can send the statements for the charges through Mr. Vanderhorst's office. Anything else, Mr. Vanderhorst?
No, Your Honor.
You're
Thank
free to
you.
go. Have a good day.
You too.
Que tengan buen día. Hasta luego. Have a nice day. Andrea Reniger versus Ronald Reniger.
Court will note the appearance of Ms. Redmond on behalf of the plaintiff. This matter is before the court on the plaintiff's motion regarding property. I have reviewed all of the, again, the petition. The court notes that it is now 9:46 a.m. The matter was set for 9:30 a.m. The defendant has not appeared in this matter. I do note, Ms. Redmond, you had asked that the matter be set to exchange the property on June 29, 2024 between the hours of 1 and 2 p.m. I don't know, and I know you attached an order, but I had also wrote some notes here that anything that is not picked up on that date would be awarded to plaintiff and defendant would have no further claim to the property. Is that in your order?
I can check right now, Your Honor.
Okay.
I have it in front of me. Any of defendant's personal items that are not picked up on June 29th are awarded to plaintiff.
Okay. Then I can, what I'll do is I'll enter that order and that will obviously cover everything and hopefully the matter gets resolved.
Okay, thank you very much.
Thank you. Have a good day.
You too. Alyosha Caldwell versus Brian Cunningham Senior.
Court will note the appearance of Mr. Magnuson on behalf of the front of the court. This matter is before the court on the front of the court's motion for entry of order requiring genetic testing. The plaintiff has failed to appear on 2 prior occasions. Mr. Magnuson, I'm going through your order, and otherwise it looks fine. The only thing I would add, and I don't know if you want to do that at this point, was to put a provision that if again, the plaintiff does not appear within that time, that the court will suspend any and all payments or public assistance made to the plaintiff for and on behalf of the minor children or child until such time as she complies with the order for genetic testing. Do you want to include that now or wait until she doesn't show up next time?
I can go ahead and include that now and resubmit it.
Okay, if you would do it under 7-day, and then we'll get it entered, and that way, if she doesn't appear, you don't have to come back in at that
Right.
to know what to do.
Okay.
Okay,
This is for 2 cases, Lindsay McKediak versus John McKediak, and 2024-391 PP, John McKediak versus Lindsay McKediak. It is Monday, June 10th, 2024 at 11:16 a.m. Attorney Shelley Huffman for the respondent, Mr. McKediak in the show cause matter.
okay. We'll take that matter first because Ms. Huffman is here, and you only, just for purpose of the record, Ms. Huffman, you do not represent the respondent in the motion to terminate. Is that accurate?
That is correct.
Okay. Okay, so Ms. McKediak, you filed the motion to show cause. You can proceed. Would you like to make an opening statement or simply proceed to your proofs?
Just proceed.
And you're gonna have to speak up so we can hear you.
No, I don't need to make an opening statement.
Okay. Ms. Huffman, do you wish to make an opening statement or proceed to proofs?
I will waive opening.
Okay, thank you. Ms. McKediak, you can proceed and present any evidence that you wish. If you are going to testify, you're going to need to be sworn in. Do you wish to testify?
Yes, I don't understand the difference of.
Well, when you file a petition, all there are is allegations. That's not evidence. It's just allegations.
Okay.
If you are going to want to have that be evidence, you're going to have to testify to that. So that's what I'm asking you. Do you want to testify or you don't want to testify?
No, I guess, no.
If you don't want to testify, then the court's going to dismiss your petition because there'll be no evidence for the court to make a determination on.
Oh, okay, well then I guess I have to be sworn in.
Speak up, please.
I said then yes, I have to be sworn in?
Okay,
And nothing but the truth.
Yes.
go ahead, Ms. McKediak, you can testify.
He just calls me when he's drunk and threatens me and threatens my children. And he said that he's gonna bury me. And then he's mad about the PPO. So he that I filed in the first place. So he said he was gonna get a PPO, and he's recently, which
Okay, ma'am, just to clarify, just so we know, because you made various allegations, I don't want general statements. If he contacted you, give us the date and the time when he contacted you as to each time.
Okay, March 18th, and January 20th.
Okay, are we talking 2024?
2024, February 7th, February 11th.
Okay, let's take them one at a time, so then we can get the evidence. So you mentioned the 3/18/2024 first. Let us know what happened on that date.
He called me and told me to go myself.
Okay, anything else on that date?
He called me a clown due to the fact that he thought that the PPOs have gotten dropped from the last court date. He called me off of somebody else's phone, so I answered off of.
Okay, again, what date did he call and what did he say?
That was the date in which I'm telling you that he called me a clown.
On the 18th, on March 18th, 2024. Okay, anything else that happened on that date?
No,
Okay, what's the next date that we're talking about?
February
what?
February 7th,
Is that 2024?
2024. Like, he called me and he said that, you know, he was gonna take everything in divorce. I was gonna have to live in a box. He's says that he'll pour acid all over me, so that way I'll never look good for another man and no one will ever want me, and that he's gonna make sure me and my kids have nothing. He does this when he gets intoxicated. So it's normally when he does it. When he's not been drinking, then he's usually, you know, well, I don't get any, we don't contact each other, but when he's not been drinking, then
Okay, all that I don't need to know. I just need to know what happened on what dates.
okay.
What happened, what are any other dates that you have?
Yeah, it's February 11th. He was in Florida,
Again, is that 2024?
2024.
What was said?
Just the same thing, name calling me junkie loser, and he said that he's gonna have someone come and he's in another state, so it won't be him, and that he'll get the kids, and just a bunch of nonsense, really.
Okay, anything else?
No.
Any other dates that the court has to be concerned about?
Well, I hate having to do this. The other day he called my mother saying that he was going to.
Okay, ma'am, I'm not concerned about him talking to any other third parties. The PP only keeps him from contacting you. So
Right.
he
But
can
it
talk
was
to-
correct.
Hold on, ma'am, don't interrupt me. I'm trying to explain this to you.
Okay.
He can only prohibited from speaking to you. He can speak to any other third party in the world that he wants to. So I'm only interested about when he's contacted you.
Okay. That's the only reason I brought it up, because it was a threat.
Okay, you've addressed the March 18th, 2024, February 7th, 2024, and I think February 11th, 2024. Is that the extent of it?
I mean, yeah, there's been other dates, but yeah, that's.
Okay. Because the court will make a determination based upon those dates once we're through. I want to make sure that you have covered everything that you need to.
Well, just one, that was back in January too.
Okay, what date in January?
January 27th, 2024.
27th?
Yes.
What happened?
Him and his girlfriend called me and told me to get my ducks in a row.
Hold on, you said his girlfriend called you or he called you?
Him and his girlfriend.
Excuse me?
Him and his girlfriend.
Okay, go ahead.
And told me to get my ducks in a row because it was after I filed and he had been served with the PPO, and he was angry about it. So they were threatening me that he was going to file a PPO back. And
Okay, when you say them, I'm not concerned about what the girlfriend said. I'm only concerned about what he said, because as I told you just a moment ago, I'm only concerned about any communication he has with you.
I'm telling you what he said.
Excuse me?
I'm telling you what he said.
No, you said they said, and I said, I don't care what the girlfriend said. I'm only concerned about what he said.
Okay, well, I guess I meant when he said them, like that they were going to, this is what he said.
Okay, go ahead.
That they were going to, like, that's what I mean by that they were going to file for PPO and that they were going to file for divorce and that they were going to get the kids. And so the PPO in which I was served is in his girlfriend's handwriting, and so was the divorce in which that he had filed was in his girlfriend's handwriting.
That's all the testimony that you have to give. Is that correct, Ms. McKeediak?
Yeah.
Okay. Ms. Huffman, any cross-examination?
Yes, so you indicated that on February 11th, he contacted you and was in Florida. How do you know where he was at?
Because it was a FaceTime call.
It was a FaceTime call,
Yes.
and so you could see Florida in the background?
I could see he told me it was in Florida.
Okay, ma'am, keep your voice up because it's hard to hear you. And I'm only saying that because you can answer and say what you want, but if I can't hear it, I can't consider it, okay?
And you said that was the date that he made a threat to you that he was going to, but it wouldn't be him, it would be someone else. Is that right?
Yes.
What time did he call you that day?
And I was in the afternoon. My phone broke, so I wasn't able to get like I don't have like a screenshot or nothing because my iPhone broke.
Okay, so I don't have Facebook or I don't FaceTime or anything like that. So you'll have to explain to me why is that information not available just on Facebook and only on your phone?
I guess I don't understand the question that you're asking, but I no longer have a phone
But-
or that.
Okay,
So
what I'm asking is that isn't Facebook like a cloud-based messaging service or app service or something like that? Facebook, it's out in the cloud, right?
yeah, but if it can be, but if I can't log into it anymore because the phone broke, then and I had deleted Facebook. So after everything.
Okay, so you could access it from a computer, but you just deleted it, right?
No, because it sends a link to the cell phone. It'll send like a code to the phone. If the phone that is on doesn't work no more and everything, then I couldn't access it. No.
Okay, on March 18th, what time did he call you?
He called me at night.
Like,
so that was probably like 2, 3 in the morning because he calls me when he's drunk.
and February 7th, what time did he call you?
That was at 2. I remember that one specifically being 2:22 in the afternoon because I was taking my friend to work. So I do remember that specifically being 2:22 in the afternoon.
And you were taking your friend to work, you were driving
Yep.
and FaceTiming him at the same time?
That wasn't a FaceTime call, and I can answer with my steering wheel. And it was called over a private number, so I just answered the phone.
Okay, which date did you say was at 2:22 in the afternoon?
February 7th, when he said he was going to put acid all over me, and I never looked good for another man ever again. And he was mad because I was giving my friend a ride to work, and then he was going to divorce me and take everything from me. And
On January 27th, you indicated that they were going to file a divorce and they were going to do specific things. Who contacted you? Was it Mr. McKediak or his girlfriend?
it was both of them. I mean, it was out of his phone, but it was both of them.
It was what?
Both of them.
But what did you say before that? It was off of what?
His phone?
It was from his phone?
I believe so.
Okay, and were all of these calls off of his phone?
Not all of them, no.
Were most of them from his phone?
One of them I know for sure was off his phone. But that one, I believe was off of his phone.
I can't hear you, ma'am.
That one I believe was off of his phone.
Okay, January 27th was off of his phone.
Yes.
Is there any other ones that was off of his phone?
I don't know if they're off his phone or not because they were private calls or sometimes they were, it doesn't mean it wasn't off of his phone. It could, like if it was private phone calls or off of somebody else's Facebook, it doesn't mean that it wasn't off of his phone.
You indicated that on March 18th, I believe you said that he called you from a different, one of these dates he called you from a different number. Do you have that phone number?
No. I don't have my phone no more.
Okay,
My phone broke. I had to get a new phone. I don't have the phone no more.
okay, so when did you write this this
But I-
motion?
Sorry.
When did you write this motion with all of these dates on it as to what was said?
I wrote it back in March.
And how did you remember what was said on January 27th or specifically January 29th or any specific date?
Because I wrote it down. My phone broke after I filled like this out, but I wasn't expecting my phone to break.
I'm sorry, I didn't understand any of that.
I wrote things down, but I didn't like expect my phone to break. Where I had things saved and it didn't iCloud like storage, and so. But I can tell you whose phone I know whose phone he called me off of. I don't know the number, but I know whose phone it was. Like a lot of time, like, you know, do you know people's numbers? Like we store people's numbers on our phone. I don't know nobody's number, but if it comes up somebody's name in my phone, okay, I know their name.
Okay, that's all. Thank you. I have no further questions.
Ms. McKediak, I note when you were giving cross examination that you said you believe that the calls were from his phone. And what leads you to believe that they were from his phone?
Well,
And speak up, please.
so because it was him.
What was that? I couldn't hear you.
Because it was him, he called me off of his phone. I would believe it would be his phone.
Okay, well, that doesn't help me. I just want to know how you're saying he called you and you believe it was his phone. And you said you believe it was his phone because he called you. Hold on. You said you believe it was his phone because he called you. Well, somebody could have another phone and call you. I'm just trying to figure out how you know that it was from him, other than if you're telling me it was his voice, I understand that. But I just wanted to clarify your statement that you believe that it was his phone.
Well, because you could push *67. Like, I don't, download text apps, I guess. Like, I don't know. I would know it was him. So, but the one phone call I know was off of his phone. It was his phone number. It came up off of his number. And then another, so I don't know.
Okay.
I just know that I get phone calls from him that are not very nice.
Other than your testimony, ma'am, do you have any documentation or other evidence of the phone calls as far as anything, messages on your phone, any confirmation from your phone bills as the calls from him, anything like that?
I had emailed the courts some videos that were sent to me, but yes, you didn't get those.
Okay, I didn't hear most of that, so ma'am, what happens, you're not coming through very loudly, so we're having to strain to hear what you're saying. All I'm saying is project. If you have to shout, do it so that we can hear.
I said I had emailed the courts some videos, but I guess you didn't get those. I don't know.
We have no videos, ma'am.
Yeah, I had sent in what evidence I had to the email that said to send it in. So I sent in that evidence.
Anything else, ma'am, that you have? Again, anything from your phone bill showing calls from the respondent or anything of that nature?
No, I don't. You can't get things off of Facebook and stuff like that. So no.
Okay.
I do have one additional question from.
Okay, go ahead.
Thank you. Ma'am, what's your phone number?
269.
Is that the same number you would have had in February and March?
Well, I have a couple different numbers. I can't tell you, but I've got a few different cell phones for my kids too.
Okay, so which phone was he calling allegedly?
It's called my son's phone and my phone.
What's your son's phone number?
I don't know it offhand. Like I said, I got them stored in my phone, so I don't know them offhand. I have to look at my phone. Like I store the numbers in my phone as the names, and I don't know the numbers. I know my phone number and pretty much 911, but I don't know numbers like that, cell phone numbers.
So you haven't replaced your phone yet?
Yes, I just replaced it the other day. I had to go to Best Buy, but it took a couple weeks because I had to have an appointment, so it was broke.
Okay, so were your contacts transferred?
Yep, my contacts were transferred.
Okay, so since your contacts have been transferred, can you tell me what your son's phone number is?
6'9".
I have no further questions. Thank you.
Okay. Ms. McKediak, just to clarify, is there any other evidence, any other testimony that you have to present?
Oh, I think he made that also a statement when we did the first court date saying how, I don't know, but that after the PPO was filed, he had said something about how that phone call back in January was made, and because that he tried to use that as him filing for his PPO, that phone call. So I don't know, I guess that's all I want to say.
Okay, thank you.
Thank you, Mr. McKediak. Did you make any phone calls to
No.
Lindsay McKediak in?
No, you have all my documentation, my PDFs from Verizon.
Hang on. Let me ask you the questions.
Okay.
Did you make any phone calls to Miss McKediak on January 27th?
No,
Did you make any phone calls to Miss McKediak on February 7th
no,
and February 11th
oh,
or March 18th?
no,
Did you make calls to her from any phone other than yours?
no. I
Did you
didn't make calls to her from my phone or
Okay.
any other.
And were you in contact with her via Facebook?
No. She has blocked off all my social media.
You have her blocked?
Yes.
And how long have you had her blocked?
Probably since at least before December of last year of 2023.
Were you in Florida on February 11th?
No.
Where were you on January 27th?
Michigan. Home. Or I might have been on the 27th. I might have actually been on the road going to Florida. Because I want to say I turned in the rental receipts to you, and I think I was back by the 5th or 6th. I'd have to go through my pictures.
Okay, could I share screen, Your Honor?
Yes, go ahead.
Thank you. Bear with me. It's the first time I've ever done this. Do you recognize this picture?
Yes.
And what is this picture?
I think it looks like of one of the bridges in Florida, and that would have been, I don't know. They're time stamped, so there's dates and times on the top of them.
So if this one says February 2nd at 11:06 a.m., would that be correct?
Yes, February 2nd. That would be on my way home.
And then this one is January 28th at 4:15 p.m.
Okay, that'd have been on my way there because I was only down there for like 3 or 4 days, maybe 5 days tops.
Okay, and so if you went down there on January 28th, if you were in Florida on January 28th, would you have left to go there on the 28th, or would you have left the day before and spent the night?
I would have left the day before because we were driving. What's Florida? 12-hour one way or more?
So you left on January 27th?
Yeah, I had to because we left. Yeah, I'm pretty sure that was.
If I had phone records here, would any of these phone records show that you have made any calls on January 27th from your phone to any of Miss McKediak's lines that she stated today?
Yes, the phone records are from Verizon Mobile. They're the PDF of the bill of every month. They show what time, where I'm at, where I'm calling to, and what number.
Right. I'm asking you, would any of them show that
No.
you called her at any of those 3 numbers that she gave us?
No, that's why I had them all printed off and turned into you.
And I do have them all saved on my desktop. I'm just not sure how to load them.
Okay.
But I will figure it out if I need to. March 18th, did you give me records that show all of your phone calls on March 18th?
I'm pretty sure every month that was listed from the first court hearing was turned into you.
Okay. And if I were to look through these and not find any of these phone numbers that were given to me, would that surprise you?
No.
In fact, none of these phone numbers are going to be listed on here, are they?
No.
Okay. And so that was March 18th, February 7th. If it states that you started making calls at 4:04 p.m. and you ended making calls at 7:16 p.m., would that be accurate?
No.
If that's what it says on here, would it be accurate?
What? Oh yeah, on the PDFs? Yeah,
Yes.
that the PDFs are from the Verizon company. You can't alter them, you can't change them. That's
Okay.
your printouts to pay your bill. Those are exact usages of my phone. Where I was, where I'm at, and who I'm calling, and what times, and how long the calls were.
Okay, so listen to my question. On February 7th, if it indicates that at 4:04 p.m. you started making calls and you stopped making calls at 7:16 p.m., would that be accurate?
Yes.
Okay, and that none of those calls on here would have been from or to any of these three phone numbers.
Correct.
Okay. And the same with February 11th. Nothing on February 11th is going to show that you made any calls to Ms. McKediak, is it?
Nope.
Ms. McKediak indicated that you contacted her on February 11th and that you FaceTimed her on February 11th and you were in Florida. Is that true?
No.
By that date, you had already rented a vehicle in Michigan, is that correct?
Yes.
And if it says that you rented a vehicle on 2/5/2024 and you returned your vehicle at 2/24/2024 from Kalamazoo Battle Creek International, it looks like AP. Would that be correct?
Correct.
So if you were in Michigan renting a car, you would not have been in Florida. Isn't that correct?
That's correct.
And did you ever state that you would pour acid all over her so that no one else would ever want her?
No.
Do you have any reason to have contact with Miss McKediak?
Absolutely not. We're going through a divorce and I have a PPO on her and she has one on me.
Is there anything else you would like the court to know?
I mean, I apologize for their time being wasted today with these proceedings. You can read through the statements, see all the inconsistencies and everything, and we'll have to be doing it again because she's been contacting me violating her PPO.
Anything else, Ms. Huffman?
No, I would like to just make an offer of proof that I do have these.
Well, I'm not gonna take an offer of proof. What I'm gonna do is, if we're gonna have to do that and you can't submit them through the Zoom, which I guess, Ms. Hoffman, I only admonish you in this matter, if you're gonna submit something like that, you need to prepare to be able to do that. And the court's always available if somebody wants to call and check to see that the equipment works and their equipment works, et cetera. And so I'm not going to take an offer of proof when you aren't able to submit those, and you could have done that. Anything else, Ms. Huffman?
No, I have nothing further. Thank you.
Ms. McKediak, you have a right to cross-examine Mr. McKediak if you wish to do so. Do you have any cross-examination?
I just want to say you can rent a vehicle in Michigan and then go to Florida, and that is what he did. I mean, there was a
Ma'am, is this a question?
I guess is there does she have the receipts of when he rented the vehicle and where he returned it at? Is that
I have no idea.
was that because he definitely called me and from Florida and stated that he was in Florida.
Okay,
So
that's not a question, ma'am. If you have a question for Mr. McKediak, you can ask your questions now.
what? I don't have any questions for him. I
Okay.
mean,
That's what I was asking. Well, what I'm gonna do in this matter, and I'm not gonna
Your
penalize
Honor.
Mr. McKediak, because, go ahead.
I was able to pull up the Hertz. I have those up right now, the rental receipts. They
Okay.
indicate that he
Okay.
rented the, sorry.
Okay, what I'm gonna do, because you can't get the other, and I think it is germane and important, and I don't want to penalize Mr. McKediak because because Miss Huffman is not computer literate in this matter. So what I'm gonna do is we're going to adjourn this matter to next Monday at 11 o'clock. I will have Miss Huffman make paper copies and submit all those proposed exhibits to the court in paper and send copies to Miss McKediak as well.
Miss McKediak, would it be okay if I email those to you, or would you rather them be in mail?
yeah, that's fine. But I mean, I know what happened, so I don't need them.
Well, ma'am, they're gonna be, she's gonna, I presume, offer those as exhibits. You should have the exhibits. So if she's offering to send those, you can decline that, but it's up to you.
Yeah, I mean, why would I need them? I know he called me.
Ma'am, do you want them or not?
No.
Okay, thank you. Ms. Huffman, get those to the court though, so that we have those.
I will do that, and I do apologize. I'm sorry.
Okay, we will adjourn until next week at 11 o'clock a.m.